Hello friends, welcome to Awdhesh Academy. Friends, today we are going to learn about the administrative structure of fighting corruption. In the central government, the highest office for fighting corruption is CVC, that is Central Vigilance Commission. Then you have Central Vigilance Officer, which are there in all the departments. And then we have CBI, or Central Bureau of Investigation. Now, CBI we will deal in a separate chapter. Today we will learn about the CVC and the CVO, that is Chief Vigilance Commissioner and the Chief Vigilance Officer. So the CVC, or the Chief Vigilance Commission, this was set up in 1955. It was an administrative vigilance division which was set up by Ministry of Home Affairs for anti-corruption measures. Then after the recommendation of the Santhanam Committee, in 1964, the Central Vigilance Commission was set through a Government of India resolution. So it was set up by a Government of India order. In 1998, the CVC ordinance was issued to give it a statutory status. So we have to differentiate. Earlier in 1964, it was only by the Government of India order. The matter has not gone to the Parliament. An act was not made. In 1998, an ordinance was made for CVC, and in 2003, the Chief Vigilance Commissioner Act was passed by the Parliament, and so it got full-fledged statutory status. Let us first know the constitution of CVC, that is Central Vigilance Commission. The Central Vigilance Commission is headed by Central Vigilance Commissioner, and there will be not more than 2 Vigilance Commissioners who will be working under him. They are appointed by the President of India for a period of 4 years or till they attain the age of 65 years. What are the functions of CVC? The CVC supervises the functioning of CBI investigation under Prevention of Corruption Act. You know that CBI investigates many other types of cases. Like criminal cases also they investigate if it is referred by the state government. So other than that, only the Prevention of Corruption Act, if any matter is being investigated under it, that is supervised by the CVC. It supervises the complaints of corruption against the officers of All India Services, that is IAS, IPS and IFS, Central Government Group A officers and officers of Central PSUs and autonomous organizations like IITs and IIMs. It also investigates the complaints which are received from the government. It can order investigation into complaints. It advises the central government or its agencies and departments on corruption related matter. See, what happens that when a matter has been investigated, inquiry has been completed in any departmental proceedings, then the matter is referred to the CVC and the CVC's advice is taken before any action is taken against the officer. In the same way, when the CBI investigates a case of corruption, then also the matter may be referred to CVC for its opinion. It oversees the work of Chief Vigilance Officer, and the Chief Vigilance Officers are appointed in each and every department or public sector undertaking. So their work is also supervised by the CVC. Now we will know about the Chief Vigilance Officer. Each organization of the central government has a CVO or Chief Vigilance Officer. Like Custom and Excise Department, there will be a CVO who will be called DG Vigilance. In the CBDT, that is the Indirect Tax Department, there will be a CVO. In a public sector undertaking like SAIL, NTPC or any department you can think about, every department will have a CVO, and CVO is the apex or the highest authority for investigation of the vigilance cases or corruption cases, and they basically report to the CVC in this matter. Most CVOs are outside the department on deputation. Usually the CVO come from outside, like the central government deputation. For example, the CVO of the SAIL or the NTPC will generally be an outsider from a central government. But sometimes he may be from inside the department also. For example, in the customs department or the income tax department, the CVO is generally from inside, that is the IRS officer themselves. They report to the head of the organization. For administrative purpose, they report to the head of the organization. The CVOs act as a nodal point to CVC and CBI for all vigilance related matters. So if suppose CVC or the CBI want certain information, then they can approach to the CVO and the CVO will coordinate and they will be the nodal officer for all these matters. CVOs are guided by CVC while performing their duties. So CVC keeps on issuing different instructions and the CVOs has to follow those instructions. They are bound by those instructions. Now, what are the functions of CVOs? CVOs have basically three types of functions. They do three types of vigilance. One is preventive vigilance, punitive vigilance, and surprise vigilance. Let us know these things in detail. First is the preventive vigilance. As they say, prevention is better than cure. So if you can prevent the corruption, nothing is like that. Because once the corruption has taken place, you will not be able to undo all the damages. So the best thing is that corruption is prevented. How that is done? Let us see the different charters of the CVO which help in preventing the corruption. The first is modify existing procedure to reduce scope of corruption. If the procedures are complex, chances of corruption is high. If you can modify this procedure in such a way, make it simple, then the chances of corruption will be lower. Simplify procedure and minimize the causes of delay. If the delay is not there, corruption will be less. Review the regulatory functions, because the more regulations, the more corruption. So if you can reduce the regulatory functions, the corruption will automatically come down. Monitor the use of discretionary power. Whenever somebody has misused his discretion, action can be taken. But can we standardize the discretionary power? If we can standardize the discretionary power so that it is reduced, the chances of corruption will be reduced. Educate the citizens through different media campaigns. You will find generally the advertisement being published in the newspapers, vigilance officers of the department. And so that is also one method. You can educate the citizens in this matter. Identify the areas of the department which are prone to corruption. Prepare list of officers of the doubtful integrity. Now this is also a very, very important thing, because before the officer is actually caught into corruption, if his actions create a doubt, then CVO can prepare that list of the officers of doubtful integrity. They can send it to the head of the department so that those officers are not given the important charges and they can be prevented from doing corruption. Prepare agreed list in consultation with CBI. This is also very, very important thing you should know, that CBI along with the CVO prepare a list of the corrupt officer which is agreed by both CBI as well as the department. So this agreed list is prepared by them and these officers are kept under watch. And during that time, they are not given any important charge. So what happens that if you are falling in agreed list, then you cannot be given any important charge in the department. So this is also a very important preventive method, because by this, the corrupt officers will not be given an opportunity to engage into corruption. And it will also ensure periodical rotation of the staff. Because if the same staff is posted in the same charge, he will develop an excess and commit corruption. Therefore, if the officers are transferred from one post to another in a frequent manner, then the chances of corruption become less. So that is also the responsibility of CVO. Now the second part is the punitive vigilance. Punitive means punishment. You do something which is actually going to punish the corrupt officers. So what are these things? Number one, he receives the complaints from all sources. So from whichever sources the complaints comes, it will be generally referred to the CVO, and CVO will take investigation and they will start action against them. Then they can investigate a specific and verifiable allegation. If the allegation has any verifiable fact, then they can investigate. For example, if suppose it is given that this money has been given to this fellow, this government officer, and he has deposited this money in this bank account. So if the details are there, you can always go and check up whether the fact is correct or not. Or suppose the information is there that this particular government officer has acquired so much of property and the property details are there, this is again a verifiable thing. You can verify, and if the verification is found to be right, then action can be taken. So whatever verifiable details are there in the complaint, the CBO can investigate. They should ensure the timely issue of charge sheet to officers. Normally the investigation is done by the internal officers of the department. So there is an inquiry officer, there is a departmental inquiry, but CBO monitor and see that the inquiry is completed within the reasonable time and action is taken against the officer. They should also see that the speedy appointment of inquiry officer to inquire complaint. They should ensure that expeditious investigation report and order of the competent authority is taken to punish the officer. They should also ensure disposal of vigilance cases within the specified period. So if there is any vigilance case against a particular officer, then that person should be either punished or he should be proven to be innocent, or he should be allowed to be let off within a reasonable period, because the officer should not suffer and the department should also not suffer. So this is part of the punitive vigilance. The third is about the surprise vigilance. So the CBO is not only sitting in his office, they are also doing a job of surveillance and detection. So if suppose they come to know, or from their own intelligence sources, they know that certain corruption is taking place in a particular branch of the office, then they can keep surveillance on them and they can take the action suo moto. So their job is to gather intelligence on corruption, and they should conduct surprise inspection in sensitive areas to detect the cases of corruption. So if they know that some wrong has been committed at particular office, they have the power to conduct inspection and detect the fraud. They can undertake prompt and adequate scrutiny of property return and intimation. So if the department, as we are aware that every officer has to submit his property return, if they find that there is something wrong in that, they can take prompt action on that. They can also monitor the cases of investigation, disciplinary action on monthly basis. So whatever disciplinary actions are taken against the government officer in a particular department, they also monitor and see that the action is proceeding in the right direction and appropriate action is taken against the officer. So friends, we have learned today about two important organizations which act as the administrative machinery for fighting corruption, that is CVC and the CBO. And we shall learn about the CBI in the subsequent lecture. Thank you very much for watching the video. Friends, today we are going to learn about Central Bureau of Investigation, or CBI. We already know a lot about CBI because CBI is always in the media. They are investigating the most important cases against the public servants and also the most important criminal cases. So let us understand about CBI. First of all, history of CBI. The CBI was established in 1941 as a special police establishment tasked with the domestic security. It was renamed as Central Bureau of Investigation on 1st April 1963. CBI has two divisions. One is the Anti-Corruption Division, which looks after the corruption cases, and other is the Special Crime Division, which looks after the different criminal type of cases which are referred to the CBI or which is investigated by the CBI. So first and the foremost and the most important is Anti-Corruption Division. Anti-Corruption Division of the CBI deals with the cases which are booked under Prevention of Corruption Act 1988. We have already learned about the Prevention of Corruption Act in the previous lessons. Cases under the IPC or the other laws involving bribery and corruption. Cases which are pertaining to the serious irregularities committed by a public servant, that is also looked after by the CBI. Cases pertaining to the state government, referred to it by the state government or by the higher courts of India. We know that the CBI is having the jurisdiction only on the central government officials and central government cases. However, there is a specific provision which permits that the state governments can refer the case to the CBI, or the higher courts like High Court or Supreme Court can also refer any case to the CBI if they feel that CBI can investigate in a better manner, or because they want to remove any sort of doubt and ambiguity in their investigation. And so in order to see that the investigation is done in impartial and fair manner, they often refer the case to the CBI. So that can also be investigated by CBI. The Special Crime Division of the CBI looks after the economic offences and other criminal cases. The criminal cases, which includes offences relating to internal security, espionage, sabotage, narcotics and psychotropic substances, antiquities, murders, etc. And all the cases which are referred by the state government or the higher courts of India, that can also be investigated by the Special Crime Branch of CBI. Now, CBI is the apex agency in India as far as the investigation of the criminal or corruption cases are concerned. They also display a high degree of professionalism. And in order to ensure that CBI does not become a handmaid of the government in power, particularly the central government, it has been provided that CBI will have autonomy in several matters, and particularly when the director of the CBI is appointed by the government. Government just cannot pick up any director, any IPS officer for appointment of the CBI or remove them as and when they want, which is there in most of the states when the DGP or any police officer can be appointed by the state governments or even in the central government in other departments, and they can remove also whenever they want. You have to understand that the CBI can investigate the matters not only relating to the lower government officers, but also it can investigate the matters relating to the politicians, including the Home Minister and the Prime Minister and the Chief Justice. So it can basically investigate the cases against all the top officials or the top politicians of this country. And therefore, in order to ensure that the senior police officers are not influenced by the politicians, there has been specific provision for appointment of the CBI director. The appointment of the CBI director is governed by the CVC Act of 2003, and CBI director has a term of 2 years. So CBI director cannot be removed before 2 years of term. So he has that level of security which is generally not there to any other police officers. CBI director also cannot be appointed by the Prime Minister according to his will. CBI director is to be appointed on the recommendation of the CVC by a committee which is consisting of Prime Minister, who is the chairman of the committee, leader of opposition, who is a member of the committee, and the Chief Justice of India or the Supreme Court judge recommended by the Chief Justice, who shall also be a member of the committee. So this committee basically decides as to who should be the next CBI director, and only then the CBI director can be appointed. Now, when the CBI start investigation, they have to take permission in certain cases and they don't have to take permission under certain cases. As far as the matters relating to the central government is concerned, and the issue is outright payment of the bribery, which we normally call trap cases. That means somebody is paying bribery and somebody is accepting the bribery and you just cash them. So that are generally called the trap cases, or where the person is caught red-handed. In that case, no permission is required from any higher authority by the CBI. So if CBI has the intelligence that money is to be paid from person A to person B, then they don't need any permission. They can straightway trap the person and arrest them. CBI can start investigation against any officer of the central government, provided that they get the requisite approval. Now, earlier they were not required to take approval, but now there has been provisions that they have to need permission. It was earlier provided that if CBI want to investigate a case of the officer who is of the rank Joint Secretary and above, then the approval of the competent authority should be taken within the CBI, that is the additional director or a special director or the director of the CBI. But now, certain amendments has been carried out in July 2018, and a clause 17A was inserted in the Prevention of Corruption Act, and according to this new clause, prior approval of the competent authority is now needed if the alleged offence is relating to any recommendation made or decision taken by the public servant in discharge of his official function or duties. What does it mean? That if suppose you are a commissioner of customs or income tax, or you are a secretary somewhere, and you have taken a particular decision while discharging your official duties, in that case, if CBI feels that there is a corruption angle involved in that, then they need the permission of the requisite authority or the competent authority. So in case of Group A officer, it is normally the ministry, and in case of the lower rank officer, that is Group B and below, it is generally the head of department. So you need the permission of the competent authority before CBI can start investigation of any such cases. That is limited to only when you are taking a decision in your official capacity. So in that cases, but if there is a trap case, if somebody is taking bribe, then this provision is not applicable and the CBI can start investigation directly. After the investigation has been conducted by the CBI, they have found some evidence, but before they file a prosecution in the court of law, they require permission from the competent authority again. Accordingly, the permission of central or state government is required to prosecute the officers. Permission is given by the authority who is competent to remove the officer. For the Group A officer, it is the ministry which can give the permission, and for the Group B and the lower rank officer, it is the head of department which gives the permission. So CBI has to take permission before starting the investigation, and CBI also need permission before filing the charge sheet. It is to ensure that the government officer who are discharging their duty honestly, they are not punished because of the bona fide decisions. CBI is a very, very important authority as far as the government of India is concerned, and therefore it is supervised by multiple agencies. It is supervised by 3 ministries of the government of India and 2 constitutional bodies. So Ministry of Home Affairs actually supervise the work as far as the cadre clearance is concerned. When the officers are posted in the CBI, then cadre clearance is required, and for that Ministry of Home Affairs is responsible. DOPT is responsible for administration, budget and induction of non-IPS officers. Then Law and Justice Ministry is responsible for public prosecutors, because public prosecutors are required to fight the case in the court of law. So in that connection, Law and Justice Ministry is required, and Union Public Service Commission, that is UPSC, is required for the officers above the rank of Deputy SP, and the CVC is also supervising as far as the anti-corruption cases are concerned. That we have already learned in the previous lessons when we were dealing about the Central Vigilance Commissioner. So we have found that CBI is supervised by 5 agencies, and CBI has been given a reasonable amount of freedom to investigate the cases, which is not available to other investigating agencies, because its director's term is secure, and it is constantly under the watch of the higher courts and the media. But nevertheless, it is still dependent upon the government of India, because for the funding, for the manpower, and therefore sometimes CBI has been called as the caged parrot also by the Supreme Court or by the director himself. He has admitted. So it still has the control, and interestingly, the CBI has to investigate the case against their own ministers also, and so it becomes a little complex matter. So today we have learned about the Central Bureau of Investigation, what are its functions, how the CBI director is appointed, what are its powers and responsibilities, how supervision of CBI is done. So I hope that you got all the information about the CBI. Thank you very much for watching the video. Friends, today we are going to learn about Lokpal, which is an important topic for the Ethics, Integrity and Aptitude paper. We know that Lokpal was a result of a movement which was started by Anna Hazare, and it has actually caught the national headlines for several weeks in 2012. So what is the history of Lokpal? What are its power? How it is appointed? So let us learn things about Lokpal today. Let us first know the historical background of Lokpal. The term Lokpal was coined first by Dr. L.M. Singhvi in 1963. The first Jan Lokpal bill was proposed by Shanti Bhushan in 1968 and passed in the 4th Lok Sabha in 1969, but did not pass through the Rajya Sabha, and therefore it fell. Subsequently, Lokpal bills were introduced several times, but they were never passed by both houses of parliament. 45 years after its introduction, the Lokpal and Lokayukt Act 2013 was finally passed by the Parliament and received the assent of the President on 1st January 2014, and thus Lokpal became a legal entity in 2014. Let us now understand some of the salient features of Lokpal. Lokpal is an ombudsman. Now we have to understand that Lokpal is not like a CBI. The CBI collects the intelligence and investigates it and also prosecute the persons. Lokpal is an ombudsman. Ombudsman means if you have any complaint, you go to that authority and that authority will sort out your problem by doing the needful investigation or doing the needful action. These ombudsmen are present in almost every government department, like you will have in public sector undertaking, it can have, then customs it has, income tax it has. So almost in every government department or many government department, the concept of ombudsman is there. Ombudsman is basically an authority where you can go and express your grievances, which will be sorted out by the ombudsman. So ombudsman is the Lokpal. Lokpal is in the nature of ombudsman and Lokayukt is in the nature of ombudsman for the state. Lokpal is the ombudsman for the central government. The armed forces and the judiciary do not come under the ambit of Lokpal. The Act also incorporates the provision for attachment and confiscation of property acquired by corrupt means even while the prosecution is pending. See, normally what happens that if suppose some officer is charged with corruption, then it takes years and years to prove that actually that person is corrupt, because the matter has to go to the court and courts take several years to decide that the person is corrupt or not. Now during that time there is a possibility that the person who has acquired an illegal property may dispose it off. So Lokpal has the power to attach the property of the corrupt people even when the prosecution is pending. The states will have to institute Lokayukt Act within 1 year of the commencement of the Act. Let us now understand the other salient features of Lokpal. The Lokpal will cover all categories of public servants, including the Prime Minister. So the top level to the bottom level, all category of public servants are covered under Lokpal. It has been made mandatory for public servants to declare their assets and liabilities along with that of their spouse and dependent children to the government. But so far it has not been implemented in the sense that government has sought for this information several times and ultimately they kept on postponing the dates, and so this provision has also not been implemented fully. The Act also ensures that the public servants who act as a whistleblowers are protected, and for this purpose a separate Whistleblower Protection Act was passed by the Parliament. Let us now understand the constitution of Lokpal. The Lokpal consists of a chairperson and a maximum of 8 members including 4 judicial members. The chairperson should be a serving or retired Chief Justice of India or a Justice of Supreme Court or an eminent person. The judicial member should be the Justices of the Supreme Court or the Chief Justice of High Court. So we can see that in this particular case, the judicial members will have the majority because the chairperson has to be from the judiciary and other 4 persons also has to be from judiciary, 4 members. So out of that total of 9 members, you will have majority from the judiciary. The non-judicial member should be a person of impeccable integrity, outstanding ability and minimum 25 years of experience. At least half of the members should be from SC, ST, OBC, minority or women. Chairman and member of Lokpal can hold office for 5 years or until they attain the age of 70 years. They can't hold office later in the central government or state government. They can't fight election for a period of 5 years. Now let us understand how the Lokpal are appointed. So the selection committee for Lokpal should consist of the following members: Prime Minister, who will be the chairman of the committee, Speaker of the House, who is a member, Leader of the Opposition in Lok Sabha, Chief Justice of India, and 1 prominent jurist as recommended by the first three, that is Prime Minister, Speaker of the House and the Leader of Opposition. What is the jurisdiction of Lokpal? Lokpal will have jurisdiction all over India, and it will have the jurisdiction over the Prime Minister, Ministers and Member of Parliament. All categories of public servant in government or the public sectors. That means starting from class 1 to class 2 to class 3 to class 4, all category of public servants are covered. Employees of the NGOs or receiving substantial funding from the government are also covered under the Lokpal. Let us now know the powers of Lokpal. The Lokpal has the power of superintendence over and give direction to the CBI. So it supervises the work of CBI. So this power has been granted to Lokpal. It can refer a case to the CBI. The investigating in of such cases cannot be transferred without the approval of Lokpal. So if Lokpal has referred a case to the CBI and CBI is investigating that case, then the investigating authority or the investigating officer cannot be transferred without the approval of the Lokpal. It can authorize the CBI for search and seizure operations connected with such cases. The inquiry wing of the Lokpal has been vested with the power of civil code, and the confiscation of assets, proceeds, receipt and benefits arisen or procured by means of corruption in special circumstances. So that can also be done by the Lokpal. It can order for confiscation of the assets and proceeds. The special power of the Lokpal is that it requires no sanction or approval of any authority for preliminary inquiry, investigation or prosecution. As we have learned that CBI require permission before they start the investigation, before filing the prosecution, and this delays the things a lot. But it has been provided that the Lokpal does not need any sanction or approval from any authority for starting the preliminary investigation or the prosecution. But unfortunately, the Lokpal is yet to become a reality. Still, the Lokpal office is to be constituted. Now, the reason which has been given by the government is that the current Lok Sabha does not have the leader of opposition to sit on the selection panel, as no party has 10% of the total member in the house. We know that Congress is the largest party, but it does not have the 10% of the total strength of the parliament. Lok Sabha, that is around 54. So there is no leader of opposition appointed in this current session. Since there is no leader of opposition, therefore this panel cannot be constituted and the Lokpal cannot be appointed. Now the government has also said that the amendment to the existing Lokpal Act to change the leader of opposition to the leader of largest opposition party is in progress, but this is still not done. However, the former Attorney General Mukul Rohatgi has been appointed as the eminent jurist in Lokpal Selection Committee in May 2018. So that's a positive development, but until the law is amended and the leader of the largest opposition party is given the flexibility or given the powers to be a member of the panel, the selection of Lokpal cannot take place. So the end result is that Lokpal is still not a reality. It is still in the paper, and the office of Lokpal is still to be constituted. So I hope that you have understood the concept of Lokpal and why Lokpal has not been started and why it is important for us to appoint Lokpal, because Lokpal will have the power to supervise or to conduct investigation against anybody in this country. So thank you very much for watching the video. Thank you very much. Friends, today we are going to provide you the updated information about Lokpal. We have already learned about Lokpal, and after the lesson was posted, there has been some development on this front. So let's understand about the latest position of Lokpal. So the first update is that Justice Pinaki Chandra Ghosh was appointed as the first Lokpal on 23rd March 2019. And 8 members of the Lokpal were also appointed, and all 8 newly appointed members of Anti-Corruption Ombudsman Lokpal took oath on 27th of March 2019. Thereafter, Lokpal member Justice Dilip Bhosle has resigned from his post citing personal reasons in the month of January 2020, and the Lokpal member Justice A.K. Tripathi unfortunately died due to coronavirus infection and cardiac arrest in May 2020. So now we have effectively only 6 members of the Lokpal, and the government has notified the rules for filing complaints in March 2020. So even though the Lokpal was actually constituted last year, but the rules were not notified under which you can file a complaint. So that rule has also been notified on March 2nd, 2020. So let's understand what are the rules for filing the complaint before the Lokpal. So the first thing is that the complaint can be filed either electronically or by post or in person. So you have been given multiple options to file the complaint before the Lokpal. The identity of the complaint or the public servant against whom the complaint has been made, that will be protected till the conclusion of the inquiry or investigation. Now this is a very unique provision, because normally when the complaint is made against a particular official, then the name of that particular official is always known. At the same time, even the person who is making the complaint, that person's name is also known. But in this, their identities has to be kept confidential till the inquiry or investigation is completed. But in certain cases, the protection against the complaint has been done away with. So this protection shall not be applicable in cases where the complainant himself has revealed his identity or any other office or authority while making a complaint to the Lokpal. So that means as long as the complainant is concerned, if he wants, he can reveal the authority, and in that case that protection is not there. The next important rule is that the complaint has to be within 7 years of the alleged offence. That means today in 2020, if the offence has been committed before 2013, you cannot make a complaint against that case. So 7 years time limit has been prescribed for making complaint in the Lokpal. It has to be accompanied by an affidavit to be sworn on a non-judicial stamp paper, and so if you are filing a complaint, you have to disclose the factual information, and if you are found to disclose anything wrong, action can be taken against you. Our Lokpal, a time limit has been prescribed that Lokpal shall dispose of the complaint within 30 days. And it is also provided that the full bench of the Lokpal will hold an in-camera inquiry of any complaint which is filed against the sitting or former PM. So as long as the complaint is against a PM, whether he is sitting PM or the previous or the former PM, then the inquiry proceeding shall be in-camera proceeding. So friends, these are the rules which has been notified under the Lokpal, and now we hope that complaints will come and the action shall be taken against the people who are doing corruption or other things which are punishable by the Lokpal Act ambit. So please update your knowledge in respect of Lokpal. Thank you very much.